Welcome to Jurisedge Academy's YouTube channel. In this video, we are going to talk about important weekly legal update from 11th April to 16th April 2022. In first important news, the Supreme Court has held that a community certificate is irrelevant issue when appointment is sought under the disability quota. In the case of Bank of Baroda versus Sushmita Saha, the Supreme Court has upheld the decision of the Delhi High Court and has said that the issue of community certificate is not relevant when the appointment was sought to be made on the disability quota and not on the basis of the community. In second important news, the Supreme Court has held that Section 366 of IPC can be invoked only when there is a forceful compulsion of marriage. In the case of Mafatlal versus State of Rajasthan, the court has held that an offence under Section 366 IPC would be attracted only when there is a forceful compulsion of marriage. The court has said that the kidnapping would necessarily involve enticing or taking away any minor under 18 years of age, if a female, for the offence under Section 363 of IPC. In the present case, the abductee had clearly stated that she was neither taken away nor induced and that she had left her home on her own free will. Therefore, Section 366 IPC would come into play only when there is a forceful compulsion of marriage by kidnapping or by inducing a woman. In third important news, the Supreme Court has upheld the decision of the Tripura High Court and has held that under IBC, decree holder cannot be treated at par with a financial creditor. In Shubhankar Bhaumik versus Union of India, the Supreme Court has dismissed the petition against the Tripura High Court's judgment and has upheld the order of Tripura High Court, which has held that decree holders cannot be treated at par with financial creditors under the Insolvency and Bankruptcy Code of 2016. The Tripura High Court has held in its original judgment that the decree holder gets a statutory status as a creditor under Section 3, Clause 10 of the IBC by virtue of a decree. Since the decree cannot be executed by operation of the moratorium under Section 14, the IBC makes a provision to protect the interests of a decree holder by recognizing it as a creditor. The interest recognized is that in the decree and not in the dispute that leads to the passing of the decree. This is apparent from the fact that decree holders as a class of creditors are kept separate from financial creditors and operational creditors under the IBC. Lastly, the Supreme Court has directed FTII to accommodate colorblind candidates in all courses. In the case of Ashutosh Kumar versus FTII, in an important judgment, the Supreme Court has directed the Film and Television Institute of India to induct colorblind candidates in all courses by making accommodation in its curriculum. The direction is also applicable to other film institutes following a similar curriculum as FTII. The court has held that art is non-conformist in character. The respondent institute is a premier institute, and one would expect it to encourage liberal thought process and not put courses connected with films in any conformist box. This brings us to the end of our important weekly legal update for this week. If you like this video, please like and share and subscribe to our YouTube channel.